Good afternoon. Good afternoon, everyone. First of all, let me say I'm very gratified by those of you, by you guys who came in person. I had the realization while walking to class that I should have just told you guys to meet online. So I apologize for that to you guys. And I'll try and be a little more on the ball about that in the future. But obviously, when the weather is crap, you should feel free to take advantage of our online meetings rather than trudging to the physical classroom, which I'm glad to see that most of you have done. So today, we're going to try and cover three things. One is I promised, I think Justin, I could be wrong about that. I think Justin, that I would talk a little bit more about what it means to have notice and the different types of notice in order to take subject to an equitable interest. We're going to talk more about the typology of legal and equitable interests. We started talking about that. Then we got pulled away into how those equitable interests get created, and then we're going to come back to it. And finally, we'll talk about equitable remedies. Okay. So, notice, as I said in the tutorial where this came up, there are three types of notice, right? There's actual notice, constructive notice, and imputed notice. And the real issue was that I was like, I know there's a difference between constructive and imputed notice, but I can't for the life of me remember what it is. So that's why we're talking about it today, right? So actual notice, right? Actual notice is when we have evidence that you actually know about the equitable interest. Can you guys see the board in the chat? Hello, Polycom. I'm over here. Zoom in. We're going to do our best. Okay, so actual notice is when the evidence is clear that, hey, you knew that this equitable interest existed. Okay. So what types of things might give rise to actual notice? It's a brand new marker, Carrie. Like it's literally, I bought it yesterday so that I could have a new marker for you guys. So I don't know how it can be faded. Oh, well, yeah, that I believe. So let's see if we can get a better by moving maybe a little bit closer. All right. Ooh. What do I keep telling you guys? I'm going to pull it down on myself. All right. So yeah, that's what we're trying. So what are some things that might give rise to actual notice? What do we think? Yeah.
I guess students in the agreement.
I'm sorry?
Students in the agreement.
Yeah, right. If you sign something that says, hey, this thing exists, you're sort of on the hook for knowing about it, right? What are some other things that might give rise to actual notice? So the idea behind registration is that the registration of an interest in land, right, makes it so that a reasonably prudent investigator would find out. So the act of registration seems to me to be more like constructive notice, and we'll talk about that in a minute. But doing that reasonable and prudent investigation would constitute actual notice. So if you go and look through the registration system and find the chain of title, that, to me, seems to create actual notice. Okay? But basically, like, if the evidence suggests that you know, right? It's more straightforward than I think you want it to be, right? It's pretty simple that if you know, you know. And that may not be the most helpful answer. But like your common sense actually can be more help than you might think. Okay? So the second type of notice is constructive notice. Constructive notice. And constructive notice is where you ought to know. We're treating you as if you know, regardless of whether you don't. So why do we have constructive notice? Where does it come from? Well, okay, yes, it's created by statute, right? You're absolutely right, Tiffany. But what's the policy issue? What's the issue out in the world that these statutes are intended to correct, right? What's the thing that we're attempting to prevent when we create constructive notice? I don't know that we're really interested in curbing the number of persons that would bring a claim because, right, there's no limit on how many people can be in the chain of title. It's just that they have to be registered. So, Tiffany, you're getting close, and Megan, you're getting close to, and so are you, Aisha, right? What's the type of fraud that we're trying to prevent? What is the type of fraud that we would be trying to prevent? Give you guys a hint. It's this type of fraud. What? I'm sorry, you blind foot fraud. Okay. Can you take your mask off because I can't understand what you're saying? You're close. You're close, right? It's not about like innocence or negligence or misrepresentation or I don't want to confuse you guys. So it's not about any of those things. But Pierre's on the right track, right? It's the fraud of willful blindness. It's the fraud of pretending you don't know about something that you probably know, right? And so constructive notice is intended to make sure that you can't avoid actual notice. Okay? Constructive notice is intended to make sure that purchasers of legal title can't go, la, 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 I didn't know. Okay? The whole idea is, yeah, you did, because we're telling you you have to be reasonable and prudent. And a reasonable and prudent person would have known about this because they would have checked the registration. Okay? The last type of notice is imputed notice. Imputed notice. And this was the one that I got confused about, I think it was yesterday, in the tutorials. So now that I have corrected my confusion, let me help you. Imputed notice is just notice that goes to somebody who we're treating like you. Specifically, your legal advisor, your agent, right? Your power of attorney, right? Any of these categories, somebody who can act on your behalf. If they have notice, you have notice, and you can have actual imputed notice or constructive imputed notice. Okay. So, yes, go ahead.
So this is trustees as well.
In what sense? Can you explain that what you're asking a little more?
In that the same item, in that same display, as a to trusting the students.
Okay. So I think we have. I think there may be a bit. So the question is, does imputed notice go to a trustee as well? And I think there is a slight misunderstanding about how the relationship works. So let me give you some examples, right? We have a purchaser and an agent, right? And then we have a beneficiary and a trustee. Okay. And I've arranged these relationships to emphasize the parallelism. Okay. What we have is we have someone who is empowered to act on behalf of and in the interest of someone else. So we have the actor here at the bottom, and we have the person who is receiving the benefit of the act here at the top. So the argument is, as I understand Travis's question, that much like how an agent who has notice of an equitable interest binds the purchaser, a trustee who has notice of an equitable interest binds the beneficiary. So the first piece of this puzzle that I want to make clear is that if we're talking about the equitable interest of the beneficiary, there's no issue with the trustee obviously knows about the equitable interest that they have been entrusted to protect. If you're talking about a trustee who is purchasing legal title for some other piece of property to add to the trust, then yes, the beneficiary is imputed to have notice because the beneficiary doesn't actually have any power over the trust estate at all. All they have is the beneficial interest. Okay, so does that answer your question? Great. Okay. All right. So let me double check one thing. Sorry, guys. Okay, good. Okay, so does the type of notice, the different types of notice, does this make sense? Do we understand this? We good? Good, 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 great. Okay. Okay, now let me tell you why we learned this. You guys remember, hang on. You guys remember we talked about equity's darling being the bona fide purchaser for value without notice. So the reason why this matters, right, is any of these types of notice, and there's no such thing as a bona fide purchaser for value without notice. So actual notice, constructed notice, imputed notice wipes this piece out. And the purchaser takes subject to the equitable interest. This, by the way, is why I was initially so puzzled by how deep and complex and extended the discussion of the distinction between law and equity is in Professor Owusu's book. Okay, because in systems with modern registration, none of this matters. The distinction between law and equity falls away because they all just go into the chain of title. Okay. But as I said last week, there are some places in the Caribbean where not all of the land has been registered. And so you do buy subject to the danger that there's an equitable interest out there that you don't know about, but that you should. Monique, did you raise your hand? I'm sorry? Which one? Sure. Okay. So the bona fide purchaser for value without notice is the only person who can extinguish an equitable interest. Okay. And what that means, we talked about this last week, right? Bona fide, meaning can't be a sham purchase. It can't be intended to cover something up or to fake being a purchase. Purchaser, so has to be an actual transaction. So no inheritance, no gift, has to be a purchaser for value, which is just another way of saying a purchaser, right? There has to be some sort of consideration without notice, okay? So I will give you guys a hint, right? In a lot of tutorials this week, when we talked about Walsh versus Lonsdale, I asked you about what happens when Lonsdale drops dead and it's Lonsdale Jr. who shows up and makes the demand for a year's rent. Okay? And almost all of you got that, an important issue in this is, does Lonsdale Jr. have notice of the equitable interest? The piece that I don't think anybody saw until today is that if he inherits, Lonsdale Jr. isn't a purchaser. Right? So did I go over that point on law and equity? Okay. I can try. I think I remember what I was saying. Does the lack of lease matter to the notice? Okay. Pierre, I'm gonna come back to you because Nicole's question is fairly easy and yours I think is a little more complicated. Nicole, if there had been a lease, there would have been no equitable interest. It would have been a common law lease, and the case would have died at that point because Walsh would have lost. Okay, but because there was no lease, then we had to then the equitable interest comes into play, and we have to deal with the possibility of the bona fide purchaser for value without notice. Okay. All right, Pierre. Legal interests take precedence over equitable ones where they both exist. So, where they both exist in different people, I should add that. Okay, so I'll put this up on the board for you guys. Legal interests take precedence over equitable interests where they're owned by different people. Okay. But in a modern registration system, the difference between these types of interests goes away because they're all just registered. And at that point, anybody who purchases with notice. Does this help here? Good. Okay. On to the next topic, if we're ready. Ready? Okay. Going once? Going twice? Okay. So one last repeat. We have legal interests and equitable interests. Okay. And where they're held by different people, legal interests beat equitable interests, so long as the owner of the legal interest doesn't know about the equitable interest. Yeah, this is one of the points that the court in Walsh makes. So the question that Monique asked is, if they're owned by the same person, equitable interests take precedence over legal interests. And that's one of the points that the court in Walsh makes, is that equity comes first where there is knowledge. Okay? Because equity sort of invokes the conscience of the person. So, you know, where they're owned by the same person, there's obviously knowledge. And so equity comes first. Right? So this I think is the key principle. Doesn't matter who we're dealing with, doesn't matter what the situation is. If the owner of the legal interest knows about the equitable interest, equity wins. If he doesn't know, law wins. Okay? And so this is why I say in modern systems, it doesn't matter. Because in modern systems, everything's registered, and whoever buys anything knows about everything because it's registered. I'm sorry, right. Yeah, we go, you know, because you should have known. If there's constructive notice, equity wins. Because remember, equity regards as done what should have been done. So if you should have known, you know. Does that make sense now? Great. Okay. Cole, do you guys feel a better? Right, that's exactly right. You should have known because of registration. Because you should have investigated the chain of title. Okay. Great. Awesome. Awesome. Okay. So moving on. Going once. Going twice. Moving on. Okay. So let's talk about the typology of legal and equitable interests. The typology of legal and equitable interests. So we talked about last week the Law of Property Act 1925, and what it says are legal interests in land. And that list is fee simple absolute, lease, mortgage, rent charge. Check my notes and make sure I have the whole list. Rent charge. Easement, statutory charge, and one more, right of entry. Okay. So, everything okay? I can't hear. I'm so sorry. Oh, yeah. We're on the typology of legal and equitable interests. Yeah. So this is one list of legal interests that may be correct, right? This is one of those things where the texts aren't giving us clear answers. You know, they're telling us something, they're giving us some information, but we're not quite sure how helpful this list is, but just to go through this list, right? You don't need to worry about rent charges. You'll cover easements in property 2. You don't need to worry about statutory charges. The right of entry is not in fact the same thing as the right of re-entry. And it took me a while to figure that out. But it's not. What it is it's basically I would refer to it as a retained easement. So it's specifically a right to enter onto a land retained by the original grantor that does not divest the grantee. Okay, so beyond that, that's all you need to know about it. So these simple absolute lease, and we'll talk a little bit about mortgages later in the semester, assuming that that's not something that we drop for time. Other ways that we can categorize legal and equitable interests, right? It may be present non-trust interests are legal, and all else. I promise I have 3 degrees. I know how to spell. All else may be equitable. All of it, there's some uncertainty in all of this. Here is what I can tell you that appears to be solid and certain. Based on quite a bit of reading. I have 3 lists. I have things that are definitely legal, things that are definitely equitable, and the things that are, I don't know. Okay. Things that are definitely legal. The fee simple absolute, the executed lease, the easement, the mortgage, and the right of entry. These are definitely legal. Here are the things that are definitely equitable. Anything created in a trust, anything created in a contract, restrictive covenants, definitely equitable. And part performance and estoppel interests. So we've talked about trusts and contracts. We talked about, you'll talk about restrictive covenants in property 2, part performance and estoppel. You guys learned, I assume you guys have learned about estoppel in your contracts class. Estoppel as an alternative way to prove an agreement. So it works the same way in property. If you have a claim that would qualify as an estoppel claim, you can estop the other party from denying you the interest in land that you would be entitled to if they performed their obligation. Same thing, okay? Same thing. Professor Owusu goes into great detail about how you prove estoppel and what you can do to prove it. And I'm going to tell you what my contracts professor used to say, that you can be the world's foremost expert on estoppel claims as a lawyer, and you will starve. Because these are almost impossible to prove. Okay? It is extremely rare to prove something like this. The other thing that he would do is he had his class schedule worked out so that a colleague of his would be in the next room over. And whenever somebody in the class would mention promissory estoppel as a way to prove the claim, he would walk over to the wall and he would bang on the wall, and the other professor would yell back, promissory estoppel, because that's what they did to amuse themselves. Okay, so the things that we don't have a good answer for. Defeasible fees. Can't give you a hard answer on whether those are legal or equitable. Life estates. And future interests. Cannot give you a hard answer on whether these three types of interests are legal or equitable in the year of our Lord 2020, or the year of creation 5781. Okay. So does this typology make sense to you guys? Like, do you understand how I've put things into these categories? What questions do you have about this? What's the last one? The last one in the middle column is future interests. The last one in the equitable column is part performance or estoppel. Okay. The last one over here in the legal column is the right of entry. Does that get you squared away, Kashana and Chad? Looks like there's some questions that I missed. Hang on, let me scroll up. Okay, not a problem, not a problem. Okay, so sure, one second. The typology of interests just means that we're putting things into categories. Okay, so we have different types and we are assigning individual interests to these types. Okay, so that if I ever say a typology again, you know that's what I'm doing. Okay, and just to run through the list, the interests that I feel confident are legal interests: fee simple absolute, the executed lease, the easement, the mortgage, the right of entry. Okay. The interests that I think are clearly equitable: interests held in trust, interests created by contract, restrictive covenants, and interests created through part performance or estoppel. Okay. And then the interests that I'm not sure which side they fall on. I think there's room to argue both ways. The defeasible fee, the life estate, and the future interest. So reversions and remainders and possibilities of reverters and rights of reentry. Okay? Marissa, I'll tell you what. Why don't I send an email out after class with the lists, and we'll take it from there. Okay? What is the basis for the categorization? Boy, the answer to that basically is started with the LPA list and looked for authority that would give me a reason to take stuff off of it and move it into equity or add stuff to it. And so that's how I created this categorization. These are the things that I found authority to put on the legal interest. These are the things that I found authority to put them in the equitable interest. These are the things where I didn't find authority that gave me any confidence. Okay? So, I would not describe this as determined at common law. I would describe this as my best effort at making sense of a whole bunch of authority that doesn't cohere. Okay, so the authority here is your professor says this is the best I've got. Yeah, that's the best I've got. So, and I know that's not great, and I know that's not what you guys want to hear, but that's the best I've got. So, okay. So, we're almost out of time. I want to talk for just a little bit about remedies. If you're still confused about this, after I email the lists out this evening, let me know and we'll keep talking. But I want to make sure that we talk a little bit about remedies before we move on. We've talked about specific performance as a remedy. There are two other forms of equitable remedies that are important for property law. Okay. Those are the injunction, and restitution. Of course, I spelled that one correctly. Okay. So, an injunction is just an order to do or not do, right? There is a common law writ that does the same thing as an injunction, but it's extremely difficult to get, right? So you may have heard of the mandamus or the writ of prohibition, which is just the mandamus says thou shalt do, the prohibition says thou shalt not do. And these are common law injunctions. But the equitable injunction is much broader and is available for a much larger set of conduct. Okay, you can enjoin somebody from doing something that they have a complete legal right to do. The mandamus or the prohibition prevents someone from acting unlawfully. So the mandamus and the prohibition only apply to unlawful conduct. The injunction can be used to prevent or to mandate lawful conduct. Okay? So we're not going to spend a lot of time talking about how you prove that you're entitled to an injunction. I just want to throw these requirements up on the board and sort of give you the very brief rundown of how they play out in property. Okay? And that's the success on the merits, weight of the harm, and the weight of the equities. And sometimes you see judges talk about the public interest, but it's not really that important for us. So you got to be able to show that you're likely to win at the end of the case, or at the very least that you've got a chance of winning. And then the court has to weigh what's the harm to you if you don't get your injunction versus what's the harm to the other side if you do. And then the benefits as well, right? So in property, the point of an injunction is to prevent the sale of the land before its ownership can be determined, before the court can determine who's entitled to what piece. Because once the land turns into money, you can't turn it back into land. But if it's still land and it turns out that the people who own it want it to be money, they can turn it into money. So, do we understand why injunctions are part of property? So, let's say that you've got A, B, and C, all of whom own a piece of property. Okay? Let's say they own it as joint tenants. Okay? And we'll talk about what that means probably next week. And A goes and purports to sell to D. And now D goes, look, I own this place. You guys get out. Okay? Court's going to be called in to try and figure out who owns what, etc. But if A's already absconded with the money, it's going to be really hard to get that back and to make sure that B and C are fairly compensated. So the point of the injunction is to prevent A from selling at all so that the court can figure out what these folks' rights are and can determine how to divide up the land. And if A wants to sell and turn their share into money, then great. B and C can continue on owning the land, or maybe they decide that they all want to sell out. But the point of the injunction is to make sure that one person can't blow up the ownership relationship in order to get their hands on some money. Does that help now? Okay. Right, exactly. exactly. So, all right, we are out of time. So the last thing that I will say just about restitution is that if, in this situation, if A had managed to abscond with the money without getting it enjoined, restitution would provide a way to get it back by forcing A to give back what they had unjustly acquired. Okay, so that's basically what restitution is, right? It's the term sort of speaks for itself. Okay. So see you guys next week. Next week, we are going to start talking about co-ownership. I'm going to fiddle around and see what I think needs to happen with the syllabus. And we'll communicate that to you next week. Okay? So, and when I get back to my office, I will send an email with the typology so that you guys have that handy. All right? So take care, and we'll see you guys, like I said, next week.